There's always a script. Sometimes it's written by a screenwriter, sometimes by a lawyer, and sometimes by a machine that doesn't sleep. In this episode, we rewind the reels, not to the plot twists on screen, but to the plot twists in court. Because behind every blockbuster, indie darling, or viral stream, there's a contract clause, a trademark spat, or an AI glitch waiting to go full drama. Forget deleted scenes. These are the ones they wish you'd never seen.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Welcome to Intangiblia, the podcast where creativity meets the fine print. I'm Leticia Caminero.
And I'm Artemisa, coded, clever, and deeply into director's cuts of lawsuits.
This episode was created using AI tools, including Artemisa here, though no faces were deepfaked in the making of this podcast.
Yet.
And since the Cannes Film Festival is happening right now, we couldn't resist. While stars climb the ballet steps and auteurs chase the Palme d'Or, we're rolling out a different kind of film feature. One where the action happens in courtrooms, not on screen. Because behind every premiere, there's a paper trail. Behind every red carpet, a rights dispute.
From Nollywood to Netflix, Tokyo to Buenos Aires, we're unspooling the cases that kept studios up at night.
So if you've ever stayed for the end credits, this episode's for you.
We're all legal. Let's begin.
We start not with a bang, but with a contrang and a superhero. In 2021, Marvel fans were lining up to see Black Widow. For some, that meant theaters. For others, the couch and Disney Plus Premier Access. Same film, different ticket. But for Scarlett Johansson, that release strategy was a bridge, not a bonus.
It was like Natasha Romanoff took down Thanos, only to get blindsided by the fine print. Here's the twist. Scarlett's contract gave her a chunk of the box office profits. But when Disney dropped Black Widow on streaming the same day it hit theaters, her cut shrank faster than a Marvel runtime with no post-credit scene.
Her lawsuit argued that Disney intentionally sabotaged the theatrical release to drive up Disney Plus subscriptions without renegotiating her deal. A bold accusation and an even bolder public clapback from Disney, who called her lawsuit callous during a pandemic.
Oh, they went full corporate villain, and it backfired spectacularly. Support flooded in from industry unions, fellow actors, and fans who saw this not just as a paycheck squabble, but a much bigger fight about streaming era accountability.
And it wasn't just about Johansson. This lawsuit tapped into a larger industry reckoning. If A-list stars can protect their back-end deals in the age of streaming, who can?
Is a legal meat. The heart of the dispute was contract interpretation in a market disrupted by tech. The term theatrical release had always meant one thing until 2020 rewrote the rules.
The case never made it to trial. Disney and Johansson settled for a rumored $40 million, 0 cents, and they've since patched things up. She's even working with them again on future projects, but the impact, permanent.
Studios now bake streaming contingencies into contracts. Actors, producers, even directors are asking, what happens when the screen gets smaller, but the stakes get bigger?
So while Natasha may be gone from the MCU, Johansson's legal move added a new superpower to the Hollywood playbook: contractual foresight.
Forget capes. Read your clauses.
From Hollywood's red carpet to Nollywood's digital trenches. In 2020, Survival of Jilili, a Yoruba language comedy film starring Nigerian powerhouse Femi Adebayo, hit Netflix. The movie was a sequel, a crowd pleaser, and a hit across the diaspora. But not long after it started trending, another channel started cashing in.
Enter a Forevo TV, a YouTube channel that played it sly. They didn't upload the full film, no. Instead, they dangled the trailer, used the poster, branded it like the original, and redirected audiences to fake links, racking up views, traffic, and ad revenue.
It was the digital version of a knockoff DVD cover. And in a streaming economy, that's not just annoying, it's lucrative piracy.
So Adebayo sued, and he didn't just sue for takedown, he sued for damages.
The case crawled through Nigeria's courts for 3 years, but in 2024, it made history. Adebayo won $25 million in damages, roughly $60,000 cents USD, and a full injunction against the channel.
The judgment wasn't just about him. He called it a win for all Nollywood because it signals something new. Digital deception has consequences, and Nigerian courts are ready to uphold that.
This was also one of the first IP enforcement victories in Nigeria tied directly to a streaming release, showing that Netflix-level visibility brings Netflix-level litigation risk.
And it lit a fire. Other Nigerian filmmakers are now filing claims, citing Adebayo's case as precedent. It wasn't just a ruling, it was a signal to every channel peddling pirated content in sleek packaging.
For creators around the world, the lesson is clear. Copyright isn't just for Hollywood, and legal tools are becoming more accessible if you're willing to use them.
So next time someone slaps your poster on a bootleg trailer to steal your traffic, channel your inner Jalili and lawyer up.
Now, for a case with a twist, even Tarantino could have scripted it better. In 2021, the cult director announced something bold. He would auction off Pulp Fiction NFTs, fragments of the original screenplay, handwritten with exclusive voice commentary.
It was vintage Tarantino, cool, confident, slightly chaotic, but there was one problem. Pulp Fiction didn't belong entirely to him.
Miramax, the studio that financed and distributed the film back in the 90s, said, "Excuses?" They sued, claiming Tarantino's NFT stand violated the rights to the film, especially the bit of it works.
This wasn't just a squabble over swag. It was the first major legal brawl over NFTs in the film industry. Tarantino argued that his 1993 contract gave him the publishing rights to the screenplay. NFTs, he said, were just a new way of publishing. Case closed?
Not quite. Miramax saw NFTs as merchandise, derivative, commercial, and crucially, not covered in the original contract because, well, blockchains weren't a thing yet.
This is where IP law stumbles over time travel. The contract was signed in a pre-digital age, but the tech exploded decades later. So the court had to ask, is an NFT a book, a collectible, or a brand new beast?
Before a ruling could drop, the parties settled out of court in 2022. Terms were confidential, but here's what we do know. Miramax is now actively exploring NFTs of its own library. So it seems they realized there was something worth fighting for.
This case lit up Hollywood. Legal teams, studios rushed to rewrite contracts. Artists got a new warning. Just because you created it doesn't mean you can mint it.
And the conversation expanded beyond film. Musicians, authors, even comic book creators started combing through old contracts to see what rights they actually held in this new digital economy.
In the end, Tarantino didn't just tokenize Pulp Fiction. He tokenized a moment when film met blockchain and copyright lawyers everywhere got nervous.
Lesson: if you're planning to auction your script in JPEGs, make sure the studio isn't holding the receipt. Let's jump to 2024, Buenos Aires. No Hollywood studio, no blockbuster name, just a quiet legal earthquake shaking the foundations of identity and AI.
The premise? Classic sci-fi, except this time it was real. Upload a selfie and a website could clone your face. Feed it a few lines of text and suddenly your voice, your actual voice, was narrating something you never said.
Sounds fun until it isn't. Argentina's public prosecutor thought so too. They filed a class action lawsuit, not against a specific AI company, but against the Buenos Aires government itself for failing to regulate the platforms enabling this digital mimicry.
It's a bold move, and it reframes the conversation. Instead of chasing every website, they aimed higher, demanding systemic regulation to protect citizens' likeness, voices, and identities in the face of rapid tech.
The case raised big questions. Can your voice be copyrighted? Is your face part of your IP? When does a synthetic version of you become a legal violation?
And the trigger wasn't just theoretical. In Argentina's growing film and ad industry, these AI tools were already being used to dub actors, simulate cameos, even resurrect long-gone celebrities, all without consent.
Unions started speaking up. Media ethics watchdogs chimed in. For once, lawyers, artists, and activists were all on the same side.
Here's where it gets even more interesting. Argentina's legal system recognizes personal image and voice as part of the right to identity, a constitutional right. So AI impersonation, potentially unconstitutional.
The case is still unfolding, but it's already influenced legislation drafts. Politicians are calling for AI transparency labels, consent protocols, and liability for unauthorized clones.
While Hollywood debates whether dead actors can star in sequels, Argentina is asking a bigger question. Do you still own your image when the machine can steal it in seconds?
This isn't just a local story, it's a global test case for how identity and IP converge. And in a world of generative everything, it's only the beginning.
Because in the end, what's more intangible than your own voice?
Now, Germany. In 2020, a case reached the Courts of Justice of the European Union, the JEU, that posed a deceptively tricky question. When a user uploads a pirated movie, what information do right holders have the right to know?
The setup? Constantin Film, a German distributor, had two of its titles, Scary Movie 5 and Parker, illegally uploaded to YouTube. Standard takedown? Done. But Constantin wanted more. They wanted to find the uploaders.
So they asked Google for the email addresses, phone numbers, and IP addresses behind the accounts. But YouTube pushed back. Under EU law, they said, platforms are only required to share the name and address of the user, not everything else.
Which led to the existential tech law question, does address include a digital one?
The CJEU said no. In a firm ruling, the court clarified that address refers to physical postal addresses, not email, not IP, not digital breadcrumbs. The ruling reaffirmed the EU's strong stance on personal data protection, even in the context of copyright enforcement.
So basically, YouTube could say, sure, here's their username in a PO box if they gave us one, which means copyright holders hit a wall if users hide behind anonymity. And legally, platforms don't have to help them get around it.
This casts a ripple across Europe's creative sector. Some call it a blow to enforcement. Others praise it as a win for online privacy.
And let's be honest, it's a classic IP tension, protecting authors versus protecting users. And this time, the privacy side took the lead.
But the ruling also invited governments to act. The court basically said, if you want broader disclosure rules, you'll need to pass better laws.
Which is what several EU countries are now trying to do. Drafting legislation that balances copyright claims with GDPR protections, a tightrope walk in stilettos.
So yes, a case about Scary Movie 5 might sound like background noise, but it underscored a much louder truth. That enforcement without access is just a beautifully worded frustration.
Or, as YouTube might say, comment below if we can find you.
Intangiblia, the podcast of intangible law, plain talk about intellectual property.
In 2023, a stylish digital poster started making waves in China's film design circles. It depicted a poised woman with a dramatic cinematic vibe, sleek, atmospheric, the kind of image you'd expect on a Cannes promo wall. Only it wasn't painted or photographed. It was generated using Stable Diffusion, an open source AI tool trained on mountains of visual data.
So, who gets the credit, or more importantly, the copyright? That was the question when the image created by an artist known online as He was reposted without permission on Baijiahao, a content platform owned by Baidu, China's search engine.
He is sued. And at the core was a fierce debate. Can an image partly created by AI be protected under copyright law? Or is it just a fancy remix from a machine that no one owns?
The Beijing Internet Core ruled in favor of the artist. They said yes because while the AI generated the pixels, the creative decisions behind the prompt, the selection, and post-processing came from a human. And that, they said, was enough for protection.
The court didn't treat the AI like a co-author. It treated it like a tool, just as a camera is to a photographer or a brush to a painter.
That ruling was China's first legal recognition of human-guided AI art as copyrightable. And it lit up Weibo, Douyin, and the Chinese creative industry with debates, hot takes, and cautious optimism.
It also pressured platforms like Baidu to revisit their reposting policies because now AI made isn't a free-for-all anymore.
And film studios, they were watching. This case cracked open legal doors for concept artists, VFX teams, and marketing creatives who are now using AI to design everything from costumes to teaser posters.
But the ruling came with nuance. If the AI does everything, no human selection or editing, it likely isn't protected. So the line is delicate. Creativity must still be human-driven.
Which is poetic, right? In the age of machine imagination, the law is still clinging to the spark of human intent.
In short, if you feed the machine and shape its output, the result might be yours. But if you're just pressing generate, don't expect a judge to call you an artist.
Or to put it more bluntly, copyright law still needs to feel your fingerprints.
In 2021, Japanese copyright lawyers found themselves watching movies really fast. Not by choice, though. A viral trend called fast movies had taken over YouTube. Users were posting heavily condensed versions of full-length films, edited down to 10 or 15 minutes, complete with narration, subtitles, and spoiler-packed summaries.
It's like binging the entire plot of Parasite while waiting for your ramen to boil. The problem? These weren't reviews or parodies. They were unauthorized edits, clipped directly from the original films and repackaged for clicks. Spoil the film, rack up millions of views, and collect ad revenue.
Japanese studios, already sensitive to piracy, had enough. In 2021, Toei Tonikatsu, two of Japan's major film houses, filed criminal charges against 3 individuals behind these channels.
Yes, criminal, not just civil claims for damages. In 2022, the court issued the harshest piracy penalty in Japanese film history, 500 million yen in damages. That's over $3,500,000, 0 cents USD per person.
To put it in perspective, they didn't upload full movies. But the court ruled that these digest edits undermine the value of the original work, dissuaded people from watching the full film, and deprived studios of revenue and control.
And unlike Hollywood, where fair use often gives room for criticism or commentary, Japan's copyright law is strict. If you're using copyrighted content, you'd better have permission or prepare to empty your wallet.
And after the ruling, fast movie uploads disappeared almost overnight. YouTube started flagging these formats aggressively. Film distributors across Asia applauded the court's decision.
And critics? Mixed reactions. Some called the penalty excessive. Others said it was about time digital piracy was treated like the industrial theft it really is.
It also raised a cultural question. In a world where short-form content is the norm, what does it mean to own a narrative? When does summarizing become stealing?
Spoiler alert, the law's opinion is clear. Clip it, narrate it, and profit from it without a license? You might be starring in your own courtroom drama.
The lesson from Japan? Fast movies make for fast lawsuits, and justice moves just as quickly when studios want their cut. This begins in Seoul, 2020. The world is mid-pandemic. A Korean film titled Alive drops on Netflix. The premise? A gamer trapped in his apartment during a zombie outbreak, clinging to Wi-Fi and hope. It's tense, stylish, and soon trending across borders.
Now jump cut to Los Angeles. The Hollywood Innovation Group, an American company, had already acquired the rights to adapt the exact same screenplay into an English language film they made Alone, which also came out in 2020.
Here's the issue. Netflix, which had the global distribution rights to Alive, dubbed the Korean film into English and released it internationally. Suddenly, Alone wasn't the edgy exclusive remake. It was a film that looked like a copy.
Except it wasn't. Hig sued Netflix, claiming that their English dub of Alive infringed on Hig's exclusive right to create the English language adaptation.
The heart of the case? Whether dubbing a foreign language film into English constitutes creating a new derivative work, or whether it's just another form of distributing the original?
Netflix argued, we licensed the full rights from the Korean producers, including all audiovisual formats. Dubbing, that's distribution, not adaptation.
She said, not so fast. In their view, any version in English, even a dub, failed under their exclusive adaptation contract.
The lawsuit made waves. It exposed a tricky fault line in IP contracts, especially in the streaming age. Because once films go global, rights get sliced and diced by language, territory, format, and sometimes assumption.
We don't have a public judgment. Most signs point to a quiet dismissal or settlement, but the industry took note.
Now, studios and streamers are drafting much tighter language around dubbing rights. English version can mean many things: voiceover, subtitles, full remakes. You better spell it out.
And for international filmmakers, there's a growing awareness that global reach means global risk. What plays in Seoul can spark lawsuits in LA.
Moral of the story, when it comes to language rights, clarity isn't just kind, it's critical.
Especially when zombies are involved.
Copyright doesn't sleep, not even in an apocalypse.
So what did we just witness? 8 IP battles, each one a different genre: a superhero contract thriller, a Nollywood piracy courtroom drama, a blockchain noir starring Quentin Tarantino, an AI identity horror flick out of Buenos Aires, a German privacy procedural, a Beijing art house debate about machine-made creativity, a Japanese short-form tragedy, and a zombie language misunderstanding with global distribution rights.
Honestly, I'd binge that anthology.
Each case brought its own tension, its own stakes, its own sense of who owns what and who gets to tell the story. Because in the end, that's what IP law in film is really about: control over the narrative on and off the screen.
And that control is getting harder to define. Streaming blurred the lines between premieres and piracy. AI blurred the lines between creator and tool. And global deals made local contracts feel, well, not quite local anymore.
We saw stars holding studios accountable. We saw platforms facing lawsuits across borders. And we saw judges redefining what a poster, a voice, or a dub even means in the digital age.
And still, through all the courtroom monologues and legal plot twists, one theme stayed in focus. The law might be old, but it's not static. It adapts. It rewrites. Sometimes it even improvises.
And creators, they're not just making films, they're navigating contracts, asserting rights, protecting identities, and sometimes accidentally launching new legal frontiers with every release.
So if you're in film and still treating your IP like background noise, cue dramatic lighting, because you're in the wrong genre.
What today's cases show us is that the future of film isn't just about pixels or platforms. It's about power, the power to own, to license, to remix, and to resist being remixed without permission.
And if you're a fan, you're not off the hook either. You can shape what gets made by what you stream, what you share, and yes, what you fast forward through on YouTube.
So whether you're a lawyer, a filmmaker, an actor, or just someone who really loves a good closing credit sequence, remember, every story you love lives inside a legal framework.
Sometimes a brilliant one, sometimes a broken one, but always one worth reading between the lines.
That's it from us today. We hope this episode gave you a new lens on the films you love and the rise behind them.
And if you ever hear someone say it's just a movie, tell them to check the docket.
This has been Intangiblia, where IP, contracts, and creativity get their spotlight.
And the credits might roll, but the rights
never fade to black.
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.